and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. It's a hot one today.
It is a hot day.
You're going to play rounders, I understand.
I'm going to spectate other people playing rounders in 30-degree heat, but I don't think I'll be getting involved. Before I head off to play rounders, we're going to quickly talk about a revisit case, actually, that we originally did in 2023 when it was at the Upper Tribunal. That's recently, on the 8th of July, been in the Court of Appeal. And the case is Adriatic Land 5 Limited and long leaseholders at Hippersley Point. And it's about the Building Safety Act, which is obviously our favourite, and in particular about leaseholder protections in Part 5. So do you want to start by going through the background to this one?
Yeah, it's a badly drafted, terribly drafted piece of legislation, and Part 5 is the worst drafted part of it, and Schedule 8 of the Act is the worst drafted part of everything. But it's an incredibly important case in the Court of Appeal. The background is that Hippersley Point is it was a new build from, I think, around about 2015. It was completed in Abbey Wood in southeast Greenwich in southeast London. Its ground floor was commercial, or is commercial, and 9 floors of residential blocks, 32 flats and all. Residential stories, I should say, 32 flats and all above it. And Adriatic purchased the freehold reversion in 2017. What then happened in 2020 is various fire safety defects, like in lots of these premises, came to light, and various work needed to be done, and various interim fire safety measures in the meantime had to be done by Adriatic. What the problem is that it's Section 20 of the 85 Landlord and Tenant Act and the relevant regulations, the Service Charge Consultation England regulations of 2003 under them, whereby if you want to charge via service charge for qualifying works, which these would be, more than £250 per tenant, you have to go through sort of consultation, which takes a long time before you can actually charge more than £250 per tenant. But you can apply to the tribunal for a dispensation of that. Like, for instance, where the works or emergency works and the likes. What happened in the first tier tribunal, Adriatic applied for a dispensation. And in the first tier tribunal, well, there was a couple of decisions, but at the end, they awarded the dispensation. You didn't have to go through the consultation, but on the basis that they would not charge the costs of applying to the tribunal to the various leaseholders. It then went to the Upper Tribunal, which is what we were talking about in 2023. And the Upper Tribunal said the first tier tribunal got no jurisdiction to do that. But in the meantime, the Building Safety Act, the leaseholder protections provisions in Part 5 had come into force on June the 28th, 2022. And the leaseholder protection provisions say that, amongst other things, in Schedule 8, paragraph 9, if you're interested, Lizzie, it says that no service charge is payable under a qualified lease in respect of legal or other professional services relating to the liability or potential liability of any person incurred as a result of a relevant defect. It's got to be a relevant building, which is 11 metres or 5 or more stories, an alternative in height. I do wish Barclays in their instructions would learn to spell stories. It annoys me they've got it as a work of fiction. But that's an aside. And it's got to be a relevant defect. Relevant steps are included now, basically. Defects in construction or conversion of buildings which give rise to a building safety risk. And it's got to be a qualifying leaseholder. So you've got to go to Rounders shortly and to explain the definition of a qualifying leaseholder in great detail would take far too long. It's basically everything was settled on February the 14th, Valentine's Day, 2022, which is when the then Ministry of Levelling Up decided to change the original law, being very romantic people on Valentine's Day. But that's another story. The upper tribunal, which we talked about before, decided that it was well, it's obviously a relevant building, it's a relevant defect, there's no question about that. So the qualifying leaseholders look to have protection because these are sort of basically professional services that you want to charge for, and the landlord was a person who comes within this. The real question in the upper tribunal was, is it retrospective or not? And to some extent, the upper tribunal said it is retrospective. It applies to people where the work had been incurred before June the 28th, 2022, when it came into force. But if they hadn't paid the service charge by that date, they couldn't be charged for relevant defects if they were qualified leaseholders. And that's when the appeal comes in.
So what points did Adriatic Land make trying to reject the claim?
Well, firstly, they tried to argue that it didn't come within Schedule 8, Paragraph 9. They actually failed. I thought they would fail on that. They are clearly sort of, trying to charge for professional services, which includes the costs of going to tribunals and arbitration and mediation and legal costs and so on. So the Court of Appeal confirmed that this came within Schedule 8, Paragraph 9. They also dealt with the whether it's retrospective or not, and this is where they differed. By a 2-to-1 majority, two of the judges, Lord Justice Newgee and Lord Justice Holgate, really followed the upper tribunal decision and said it would be retrospective because that was what the legislation was designed to achieve. It was in keeping with the legislation protecting leaseholders and getting work done quickly. But they said, a bit like the upper tribunal, it wouldn't be right to make it fully retrospective for works going back, 10, 20 odd years in the past. Therefore, if somebody had already paid the service charge before the case, then they couldn't get the money back, but they were still to pay service charges, even though they'd been billed for them. They weren't liable. One of the judges, Lord Justice Newey, said that that wasn't the case. You're supposed to interpret legislation with a presumption that it shouldn't be retrospective unless it's clear otherwise. And so therefore, any work post June the 28th or from June the 28th, 2022, qualifying leaseholders couldn't be charged for, but they could for work before that date. Well, obviously, the majority of the Court of Appeal prevailed. The other argument they tried to put forward is, it seems to be quite common nowadays that people in property law are doing this, that it was a breach of their human rights. And Article 1 of the first protocol of the European Convention of Human Rights, and a right to peaceful enjoyment of possessions. And this meant that, the legislation should be interpreted in terms of, human rights, and they shouldn't be liable. All the judges agreed on that it didn't come within the Article 1 of the first protocol. Basically, it wasn't depriving people of land, it was trying to control their use of land, and only rarely would it be subject to the need for compensation. And it was proportionate, and it was of public benefit for the legislation, so that stage failed. It's basically the majority of the Court of Appeal agreed with the upper tribunal. Whether there's going to be appeal or not is another matter. There are a few other things before you go to your rounders.
Go for it.
Well, the same day, the Court of Appeal, the same judges decided Triathlon Village and decided Triathlon Homes and Stratford Village Development Partnership, which we're going to do a separate podcast on in the next day or two. And that was about remediation contribution orders under Section 124 of the Act, and Part 5 again, which allows basically any interested party to claim a remediation contribution order from various other bodies if it's just and equitable to do so. So the leaseholders who have been charged could potentially, if just an equitable claim of remediation contribution order going back to works, not relevant here, but from July, from June the 28th, 1992 onwards. But we'll talk about that in another course, I'm sure. The other thing, which I think is extremely important, is that there's other parts of Schedule 8 which say that you can't charge service charges for qualifying leaseholders. In other situations, for instance, if on February the 14th, 2022, the flat was worth less than £175,000 or £325,000 in London, or if on February the 14th, 2022, the landlord satisfied the contribution condition, the landlord and their associates' net worth was more than £2 million per affected building. So we haven't heard the last of it, and it's to conclude and let you go. It's yet another example of this sort of complete dichotomy between qualifying leaseholders who have all these rights, and if you're not a qualifying leaseholder because of the status of the leaseholder on Valentine's Day 2022, or if it's not a relevant building, it's not 11 metres, 5 more stories with 2 or more residential units, you have no rights whatsoever. It's not the best way of dealing with things. It's not the most rational legislation. But that's it for another day.
Well, thank you very much, Richard.
My pleasure, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.